Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today, we're providing a step-by-step guide to filing a mandamus lawsuit in federal court.
This is a practical episode. We've covered the legal foundations, mandamus, the APA, the track factors. Now, we're going to walk through what actually happens when you decide to file a federal lawsuit to resolve an immigration delay.
So let's start at the beginning. What's the first step?
The first step is evaluating whether your case is ready for federal court. Not every delayed case is appropriate for a mandamus lawsuit, and timing matters.
What factors go into that evaluation?
Several things. First, how long has the application been pending? While there's no magic number, the delay needs to be long enough that a court would consider it unreasonable under the track factors we discussed in Episode 5.
What else?
The completeness of the application matters. If USCIS sent a request for evidence and the applicant never responded, that's a problem. The applicant should have done everything required on their end. You also want to consider whether there are any legitimate reasons for the delay, pending background checks, for example, that the government might raise as a defense.
Should applicants try to resolve the delay through other channels first?
It's generally advisable to make some effort to contact the agency before filing suit. This might include submitting a case inquiry through the USCIS online system, contacting a congressional representative, or reaching out to the USCIS ombudsman. These efforts aren't legally required in most cases, but they demonstrate that the applicant tried to resolve the matter before turning to litigation.
And they create a record.
Exactly. If the agency ignored multiple inquiries over an extended period, that strengthens the argument that the delay is unreasonable and that litigation is necessary.
Once someone decides to move forward, how do they choose where to file?
Venue selection is an important strategic decision. In immigration mandamus cases, there are typically multiple federal district courts that have proper venue.
What are the options?
Generally, an applicant can file in the district where they reside, the district where the agency took or failed to take action, or the District of Columbia where the agency headquarters are located. Each option has potential advantages and disadvantages.
What factors influence the choice?
Several things. How has that district ruled in similar cases? What are the typical processing times for civil cases in that court? How far is the courthouse if in-person appearances become necessary? Does the applicant's attorney have experience practicing in that jurisdiction?
So it's not just about where you're allowed to file, it's about where it makes the most sense to file.
Right. An experienced immigration litigator will consider the case law in different districts, the local rules and procedures, and practical factors like court congestion.
What comes next?
Drafting the complaint. The complaint is the document that initiates the lawsuit. It tells the court who the parties are, what happened, why the court has jurisdiction, and what relief the plaintiff is seeking.
What does a mandamus complaint typically include?
It starts with a caption identifying the court, the plaintiff, and the defendants. Then there's an introduction summarizing the case. The complaint will include sections on jurisdiction, explaining why the federal court has authority to hear this case, and venue, explaining why this particular court is the proper place to file.
Who are the defendants?
In immigration mandamus cases, the defendants are typically the government officials responsible for the delayed action. This usually includes the USCIS Director, the Secretary of Homeland Security, the Attorney General, and often the Director of the specific USCIS Service Center or Field Office handling the application.
Why so many defendants?
Because different officials have different roles in the immigration process, and the complaint needs to name everyone who has authority over the delayed decision. The specific defendants depend on the type of application and where it's pending.
What goes into the body of the complaint?
The heart of the complaint is the factual allegations. This section tells the story of the case in numbered paragraphs. When did the applicant file their immigration application? What type of application is it? What has happened since then? How long has it been pending? What efforts has the applicant made to get a decision? What harm is the applicant suffering because of the delay?
How detailed should this be?
Detailed enough to establish the facts supporting each legal claim, but not so detailed that it becomes unwieldy. The complaint needs to give the court and the defendants a clear picture of what happened and why relief is warranted.
And then there are the legal claims.
Yes. After the factual allegations come the causes of action, the legal theories under which the plaintiff is seeking relief. A typical immigration delay complaint includes a claim under the Mandamus Act and a claim under the Administrative Procedure Act for unreasonable delay.
How does the complaint conclude?
With a prayer for relief. This is where the plaintiff tells the court exactly what they're asking for. In a mandamus case, the primary request is an order compelling the agency to adjudicate the pending application within a specific timeframe.
What else might be requested?
The complaint typically asks the court to declare that the delay is unreasonable and unlawful, to retain jurisdiction until the agency acts, and to award the plaintiff costs and any other appropriate relief. Some complaints also request attorney's fees, though the availability of fees in immigration mandamus cases is limited.
Does the complaint ask the court to approve the immigration application?
No, this is important. A mandamus lawsuit asks the court to compel a decision, not a particular outcome. The court cannot order USCIS to approve a green card or grant asylum. It can only order the agency to perform its duty to adjudicate the application.
Once the complaint is drafted, what happens?
The plaintiff files the complaint with the court. This is done through the federal court's electronic filing system called CM-ECF. The plaintiff must also pay a filing fee.
How much is the filing fee?
The filing fee for a civil case in federal district court is currently $405. Fee waivers are available for plaintiffs who cannot afford the fee, though that process requires a separate application demonstrating financial hardship.
What happens after filing?
The court assigns a case number and, in most districts, randomly assigns the case to a judge. The plaintiff receives a summons for each defendant, which must be served along with the complaint.
How does service work in these cases?
Service is the formal process of delivering the complaint and summons to the defendants so they have notice of the lawsuit. In cases against federal agencies and officials, service has specific requirements under the federal rules of civil procedure.
What are those requirements?
Rule 4 requires that the plaintiff serve the United States Attorney for the district where the case is filed, the Attorney General in Washington, D.C., and each individual agency or officer being sued. Service on the U.S. Attorney and Attorney General must be done by certified mail or other reliable means.
Is service complicated?
It can be. Failing to properly serve all defendants can result in delays or even dismissal of the case. This is one area where attention to detail really matters. Each defendant must be served correctly, and proof of service must be filed with the court.
Once the defendants are served, what happens next?
The government has 60 days to respond to the complaint. This is longer than the typical 21-day deadline for private defendants because of the additional time afforded to the United States in litigation.
What form does the response take?
The government can file an answer, which responds to each allegation in the complaint. Or the government can file a motion to dismiss, arguing that the case should be thrown out for legal reasons, lack of jurisdiction, failure to state a claim, or other grounds.
What often happens in practice?
In many immigration mandamus cases, the filing of the lawsuit prompts the agency to act on the underlying application. Once the case is served, it gets assigned to an assistant U.S. attorney who contacts the agency. The agency then reviews the file and often adjudicates the application.
So many cases resolve without a court ruling?
Yes. A significant portion of mandamus cases result in the agency acting on the application after the lawsuit is filed, but before any court decision. When that happens, the parties typically agree to dismiss the case as moot.
Let's summarize the key points from this episode.
First, before filing a mandamus lawsuit, evaluate whether the case is ready. The delay should be significant, the application should be complete, and it's advisable to document efforts to resolve the matter through administrative channels.
Second, the lawsuit begins with drafting and filing a complaint that names the appropriate defendants, sets forth the factual background, asserts claims under the Mandamus Act and Administrative Procedure Act, and requests an order compelling the agency to act. Filing requires payment of a court fee and proper service on all defendants.
Third, after service, the government has 60 days to respond. In many cases, the filing of the lawsuit itself prompts the agency to adjudicate the pending application, and the case resolves without a court ruling. But if the government does not act, the litigation proceeds toward a judicial decision on whether the delay is unreasonable.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.